I'm sure council has as well. This morning I did email council the updated ones based off what the state abandoning that second aggravating factor regarding engaged in the commission of sexual battery at the time. So that one's been deleted. The state also brought up issues regarding the language contemporaneously versus previously that I said in the email that we can discuss today. I do have the verdict forms ready. The final instructions were also sent out, including all of the mitigating circumstances the defense provided in that pleading on Friday, which I reviewed. Some of them seem to overlap with one another to some extent, but to be as fair as possible, I just listed them as the defense provided them in their pleading. I did not merge any. I didn't delete any out if they were duplicates or overlapping. I was not going to take that approach right now. I wanted to put them on the instructions, and then we could talk about them at a later time, which is going to be today, obviously. Anything from the state's perspective before we dig in?
On just any matter, Your Honor, is there a couple things you want to put on?
Go for it.
Yes, sir. First, Your Honor, regarding the defense's presentation, we left here Friday understanding that they had report, and we certainly agreed and inquired the defense with respect to who else he wanted to call. I think the representation was made. There were 2 or 3 folks in the New York state put on the record that would not have an objection to working all this accommodation. Over the weekend, we have been provided 8 witnesses in New York that they would like to call. Did get that on Saturday afternoon. One of which is Joseph Quiles, so we know about him. The other 7, obviously, I'm sure came. We have asked the defense, because it's been represented, I think on the record, but asked them to do that today, for sure an email. They were only calling those additional 8 state the relation to the defendant. They support him and love him and who they are with respect to their name and relationship with the defendant. That's a lot of folks, Judge, for us to get. We have represented back over the weekend that the state has thrown out a different procedure. If they agree to this, we won't lodge an objection. This is all cumulative. Recognizing why, it is late notice. I'm not blaming the defense for that, for the way it's unfolded. However,
I mean, when you say way it unfolded, what do you mean by that?
Well, Friday, before required, it sounded as the counsel I know, these are witnesses from New York that he felt like couldn't testify because they couldn't afford or didn't have the ability to fly down here. So we put on the record, the state did that. We would agree whatever method the court's done that. The court has been over backwards in making sure those 2 or 3 folks can testify. Well, now there's 8. We have asked if they would call 1 or 2 of those, state who's present, because apparently they're all together.
No, they're not.
Okay, then I stand corrected. But state who would make the same representation 8 times, putting their relation in the record 30, that accomplishes 1. All of their names being represented during the presentation. But nonetheless, if the court does allow them, but 8 folks on Zoom, again, I'm not blaming the defense, but we've not had a chance to speak to them or propose them, obviously. We would ask that, first we would just put an objection on the record. We would, based on what they're telling us now, obviously there's some different things that obviously can be overcome. Just for purposes of the record, I just want to put all on the record as that issue. That's where we are with respect to this code. Second, Your Honor, I just want to put on the record, I know we had a little bit of email communication over the weekend. The state of Florida is abandoning the aggravating factor. He engaged in the commission of aggravating factor. Just a visit on the record Friday, the one about being engaged in the commission of sexual battery. We're doing that because we believe the aggravating factor, the first one, the prior violent felony, 2 and 3 apply as to count 2, counts 1 and 3 can apply. So we're simply just going to, we think that's cleaner, takes away from those 2 aggravating factors merging, then requiring a merging instruction. For multiple purposes, we're abandoning the engage in the commission of aggravating factor moving forward. So we will have 6. Also, for the record, we did the thought over the weekend on the especially heinous, atrocious, and cruel. We're asking to keep that. We are going to pursue that and argue that. And I think the one other thing the court did ask us was which aggravating factors apply to which count. All apply to counts 1 and 2, both first-degree murders, with we believe the exception of HAC. We are not going to argue HAC to the unborn child. Our argument is strangulation.
Okay, time out. Let me make sure I get this right.
Yes, sir.
So, HAC, aggravating factor number 3, this only applies count 1, correct?
Yes, sir. Yes, sir, that's correct.
What I'm telling the jury is, I'm going to tell the jury, here's all the aggravating factors alleged by the state. And then I'm also telling them, following aggravating factors apply to counts 1 and 2 unless otherwise noted.
That's correct.
So, for example, HAC would be the first one where I'd say, tell them first-degree murder was especially heinous, atrocious, or cruel. This only applies to count 1. That's what I'll tell the jury. The verdict form will, of course, reflect that. So give me a second.
Absolutely.
So, on count 2 verdict form, I'm taking out the heinous, atrocious, or cruel. Correct.
The state agrees, yes, sir.
Okay, so you can go, continue.
Yes, sir. And then, so just for the record, so the first aggravating factor, the previously convicted of another felony involving the use of threat of violence in a personal argument is to both. The second one, the committed for the purpose of avoiding or preventing a lawful arrest, we're going to argue as to both. As we just said, HAC will be only as to count 1. The fourth, TCP, full calculated and premeditated aggravating factor, we're going to be arguing for both, and then have intentions to kill both. As the fifth one, the victim of the capital felony was a person less than 12. We are only arguing that for the second count, obviously, the unborn child. And lastly, we were arguing for both capital felony that was committed to someone who's particularly vulnerable and is in the position of familial or custodial authority over the victim. We can argue that as to both. So ultimately, in sum, Your Honor, the third HAC and the fifth victim under 12 only apply to one respective victim. HAC only to the IS and victim under 12 only to the unborn child.
So in total, it looks like there's going to be 5 aggravating factors alleged as to each victim.
That's correct.
Okay.
There's 6 total, but yes, there are 5 as to each. That's absolutely correct.
So the last one being vulnerable due to familiar or custodial relationship. As of Friday, you weren't sure that was going to both counts. Now the state is alleging them for both counts.
We have thought about it, Your Honor. Factually, Dennis believes it's all through the wire. That was his child, so when he's caring for him, he's in his home. Also, our argument will be he's also custodial authority over his unborn child, as he thought. So yes, sir.
Okay. So in the final instructions, there's no need for me to tell the jury anything about merging aggravating factors, correct?
That's why yes, sir. We are not asking for none of these that are left merge. There's no need to now define felony murder or anything of that nature. So yes, sir, we believe it simplifies things, and the court has that correct.
Anything else you wanted to address?
A moment. I think the court wanted to talk about contemporaneous versus previous language.
Yeah, the reason why I included the contemporaneous language is that in instruction 7.10, I'm reading straight from it. Defendant was previously, and then in brackets, or contemporaneously convicted of another capital felony, a felony involving the use or threat of the use of violence to another person. In this case, he was contemporaneously convicted of the first-degree murder. It's not a prior sexual battery conviction that the state's relying upon. That's why I use that language. I understand how, if it's previous, it's certainly similar to the first aggravating factor under the statute regarding the prior conviction.
Yes, sir.
And so that's why I put contemporaneously, because it's provided in the standard instructions.
Yes, sir. Our only concern was that the actual statute itself doesn't say contemporaneously. However,
well, as of today, he's been previously convicted of it now.
Yes, and that was going to be our argument, that you convicted him Friday of those other 2 counts. So if the court wants to give that, I would
Hold on a second. So you want previously?
The state would ask to do previously or contemporaneously, so long as the defendant agrees and does not object.
Defense, give a position. The statute says previously. I'd rather stick to what the statute says. I'm not sure why the standard instruction includes language the statute does not include.
Well, and I was going to stick with the statute, Judge.
Okay. I'll just put what's previously.
And would the court make sure the defendant himself agrees to that?
Agrees to the language of the statute?
Yes, sir. Because of the discussion we just put on the record regarding the alternative, he's not requesting to say contemporaneously. If he does, we would say the previously or contemporaneously, but he's fine with or previously. The state is obviously.
It's a bit of a legal issue. I'm not sure he's going to have the legal knowledge to understand that. Or understand the distinction of the statute.
He's fine with leaving it with just previously.
State agrees.
I'm changing all the instructions and the verse forms. But your argument is going to be that the prior conviction is the sexual battery.
Well, no, sir. Our argument is as to count 1, they found him guilty of counts 2 and 3. So counts 2 and 3 sort of play in count 1.
Understood.
And then count 2, we're going to argue 1 and 3.
So you can argue the other murder as a prior felony under that aggravating factor?
Yes, sir, because they convicted him on Friday.
Okay. Makes you wonder why you wanted to proceed. Well, never mind. I'm not going to get into that. Okay. I made any changes on the verdict forms and the standard instructions for both preliminary instructions and charging instructions, which I will send a copy to everyone as well once we finalize all this. I need to change the language for the last aggravating factor. What I can do is that the victim's name is going to be actually in the instruction regarding vulnerability due to their familiar custodial authority. What I may do is just have it language for IS and say this applies to count 1, and then have another paragraph that says that for the unborn child that this applies to count 2.
Yes, sir. State agrees.
Judge, just for purposes of the record, I understand how the state is proceeding on the last aggravator, the familial. We would object to it as Mr. Quiles was not in a familial position over IS at the time. He's not her father. He's not a caretaker or caregiver. I mean, she did go over to his residence, but he was not in a familial capacity to her.
Well, the statute says familiar or custodial.
Just over a defense's objection, Your Honor.
Understood. He was also found guilty of sexual battery in a familiar or custodial relationship as well by a jury, so the jury can make that determination if they believe it's familiar or custodial or not for either IS in count 1 or the unborn child of IS in count 2. So I'll leave it up to the jury, but if you need to make a motion at some other time during the pendency of phase 2, obviously you're more than welcome to make those motions or arguments throughout the pendency of the second phase.
Yes, sir, Your Honor. We just, for purposes of the record, we want the objection noted for.
Okay, and it hasn't gone to the jury yet, too, so.
Right.
Other than the defense witnesses, any other issues from the state's perspective?
Yes, sir, there's one more, just for the record, maybe the court would The defense did let us inquire of Dr. Rohr, R-O-H-R-E-R, on Friday. We spent 35 minutes with her in this very courtroom and sort of gleaned from her what she would be testifying about. We were not asking for any rebuttal with respect to what we anticipated to say. However, talking with her, I asked her to sort of, in her testing, pull out some personality traits that she found in the defendant. She used terms like egotistical, self-centered, narcissistic, and some things that I will listen across. I just want to make sure that I'm sure the defense has made their own decision about whether to follow her. I believe they are. So at the moment that if they do, I just want to make sure the record's clear. We are listening to that. And that
Is this information that was in her report or things that you gleaned from her?
Yes, sir.
Well, hold on a second. Let me finish the question. Just for the transcript. Are these issues or information that was gleaned in her written report or things that you got from her via deposition or through interview of her?
What we were asking her to define terms in her report and asking her and sort of summarizing her opinion that she wrote in her report, what types of conclusions that she determined regarding his personality traits. She started offering those. So while she doesn't write every single one of those, I think it's clear in the report. What does eventually define antisocial personality disorder? And as we were delving into that, that's when she started describing what the personality testing showed. So our positions across, we're going to elicit that. Just want to make sure that the defendant himself is one, soliciting that, but two, the fact that they're calling it, that they probably made their own decision, but that's just something we want to talk about.
Okay.
We are aware, Judge.
Understood. So nothing else from the state perspective, anything from the defense perspective?
The last thing, judges, I think the court may already know, we did, or maybe you don't, we gave them 2 victim impact statements. We are intending on calling SF and we can't.
Not the mom.
Sir.
Okay. For whatever reason, I just wanted to clarify because as of Friday, it seemed to it'd be the mom and somebody else.
Yes, sir. That's the 2. So we did send that very late last night. We apologize. It was probably around the 10 o'clock hour. We actually had a victim advocate staff member working with the family trying to get them to get those needed. We finally got those done. We sent those last night. We're told this morning there's some objections. What I've asked before they're read is to send to us or highlight for us what they want. We'll find objectionable, maybe we'll agree without the need to discuss any further, but we just haven't seen that yet. To no fault of the defense, we hard on those over. Family worked hard on those over the weekend. And we got them late last night.
Just to be clear, Dan, we only received 1. There's only 1 on your attachment.
Were both documents in the same attachment potentially?
No, Judge.
No, 1 is clearly just SS.
So the record's clear, I'm not handing the photos. Can't control it. One's about 2.5 pages, and the other one's from SS, double spaced, about 4 pages.
The one from SS we have, the one from,
All it takes.
we did not get that one, Judge.
Did she testify at trial?
She did not.
That's ID's mom?
Stepmom, Your Honor.
Stepmom, that's right.
Yes, sir, Your Honor.
Okay. I'm supposed to have a jury in front of us in about 20 minutes. How are we looking?
Judge, I'm looking through my email, and just for the record, we did receive an email from Mr. Skinner at 10:02 p.m. last night to Bob and I saying here is 1, and it attached the one that we have had a chance to review and do have some objections to. I'm looking now, I'm looking in my spam. I do not have another email from him with this one, so having just received that, Judge, I would like the chance to review that. Obviously, it's going to take longer than I think 20 minutes to line item that.
Or if that didn't go to our mistake, I will send that, giving them a hard copy, I'll go ahead and copy it.
Who are the 8 people from New York you're trying to call off this list? 8 to 9, however it may be.
Yes, Judge, and just to confirm, I did speak with Paulette, who is the defendant's mother, or well, aunt, but in a mom type of position. She did email me this morning and let me know those who could for sure be present. As you're aware, on Friday when we found out about the Zoom, I just asked her to give me the list of people she thought would be appearing so that I could provide that to the state. I did do that, but as far as who will
Can I state something? I also want to make it clear. I didn't know it was not. I didn't know it would be an issue. I didn't know who the defense was calling in the penalty phase if the trial got that far. I know there was a witness list. I didn't really inquire beyond that. I didn't know people from out of state wanted to be present but could not be present, whether it be logistical or financial reasons. I had no knowledge of that until Friday. The state didn't object to Zoom. I made it happen with the courthouse information technology people. I didn't know it was an issue. And if it became an issue, I can't imagine the state would have objected. They didn't object Friday. But now that's why we're in the position we're in right now.
Yes, Judge, and I had no intention of making it seem as if it was the court's fault by any means.
Sure. I just wanted to make sure that was clear for the transcript. If in case it's an issue on the back end, that it was not an issue that I knew that needed to be addressed until Friday, until I inquired of Mr. Quiles.
Understood, Judge, and there may just have been some miscommunication there, because when we talked about using Zoom throughout the trial, the court had made it clear to those who had been appearing via Zoom throughout the pre-trial hearings that Zoom would not be available, and I think that's when we kind of said, okay, if Zoom is not available, then we move.
It was not available.
Right.
It's not available for members of the public to come watch the proceeding. Obviously, we had issues now with people on Zoom making sign language to your client. I was not going to allow Zoom be present during the course of a trial. It's a public courtroom. People can come watch trial as much as they want. They can probably go watch the live stream if they want. But I was not going to have Zoom be present for members of the public to come watch the trial. That's not appropriate. And nor has the Supreme Court ever said that's appropriate. They've allowed it for pretrial proceedings, attorneys to appear. Never has it been made available. And I think I've been very kind's not the right word, but I've allowed Zoom at a lot of proceedings, particularly in this case, for victim's family too, defendant's family to come present when they normally would not be able to attend certain proceedings, and I understand that. But when it comes to evidentiary hearings, when I got a job to do for a trial, Zoom was never going to be on the table. Now, for people to attend a trial to testify, that's a whole different analysis, if you ask me. But understood. But nonetheless, who are the eight or nine people you want to call from New York?
Yes, Judge. So I sent the list to the clerk a little earlier. From that list, my understanding is that today it will be Paulette Viorette who will be testifying in person, KB, Kenneth Berry on that list, in person, Curtis Hale in person, Kishana Pugh in person, and Karen Gaines in person. Or her name might be Karen Gaines McMillan, if I'm not mistaken.
Okay.
And then on Zoom, Judge, they have tried to limit those to just 3 of the 8 that were listed to accommodate what the state's request was, as far as not wanting more than that.
I mean, I haven't ruled on that. They've made an objection. I don't know what these people are going to say. You guys work it out on your own end of who you want to call and not call. That's fine. But I have not. I've chosen not to get involved on purpose because I don't know what these people are going to say.
Understood, Judge. As far as what 3 that would be via Zoom at the moment, if there's no objection, would be Vanessa Brassedy. I may be saying that wrong, but it is spelled Brassetti. I'm sorry. Let me get the exact spelling for the record. I think, or was it provided to you? Okay, great. Destiny Quiles and Joseph Quiles.
And those 3 are in New York, I'm assuming.
Those 3 are all in New York, Judge, and they would be testifying on Zoom individually.
And they're available this afternoon?
They're available whenever we need them, Judge. I did tell them to make themselves available anytime after 10. I didn't give them an exact time. I said I would let them know as we progressed exactly what time they would need to be on. I did also let them know that they would not be sitting on Zoom all day, that we would open it when it was time for their testimony, so they're aware of that. And there was one other thing, Judge.
And Dr. Rohr is the only one not on this list, I'm assuming.
And Dr. Rohr, I apologize.
Yeah.
The only other thing, Judge, is that they... Sure. And just for the record, the state would like us to put their relation to Mr. Quiles. So Vanessa Rossetti is a long-term family friend who's like in a sister type of, they grew up together type of situation. Destiny Quiles is a cousin. A niece. And then Joseph Quiles is his brother. And I believe they know the relation of the people who are in person because they've asked that.
Okay. And so those are the three you guys are calling this afternoon upon your own agreement after talking to the state about the number of people from New York.
If there is no objection from the state, we would like to call those three out of the 8 of the names that we provided.
The state not objecting with respect to 3 when it was just represented to us over the weekend that they were going to call 8 to say a very, very similar testimony, which we felt was cumulative. If they're only calling 3, there is no objection by the state so long as the defendant is satisfied with who the defense is calling on his behalf.
And Judge, just to be clear as well, I did speak to them this weekend about having them appear in a way that they could express their support, but then not necessarily all testify to the same thing. And what they have agreed to do is to state their name, who they're speaking on behalf of, because some of them are like, I'm speaking on behalf of my sister, my mother, and so as well, who would be here and present and say the same thing that I'm saying right now. We agree that that would be the way we would handle it instead of calling each and every one of those witnesses, just to avoid that very objection that we, of course, would not try to present duplicates of this exact same information or cumulative type of information. So as long as that's not objectionable, we would plan to proceed in that fashion. We have spoken with...
I'm sorry, my fault. Please continue.
We have spoken with Mr. Quiles about presenting these additional witnesses. He did want some of his family that lived and resided in New York to be able to appear, and so at this point in time, if there's no objection, then we would proceed in that manner.
And those are the 3 that the people in New York that he mentioned 2 to 3 on Friday. Obviously, that number grew. Now it's shrunk to 3, and then those 3 are testifying on behalf of other people as well. That's to his satisfaction. That's what he wanted you guys to do.
Yes, Your Honor, I think that would satisfy. And frankly, Judge, those are the people who are available. And so I think there may have been one other person he wanted, but that person is not available to do it. So they plan to speak on behalf of the person that he planned to or asked us to get.
Okay. Mr. Quiles, can you raise your right hand? Do you swear or affirm, tell the truth, the whole truth, nothing but the truth? All right, sir, you can put your hand down. You've heard the conversation this morning regarding these witnesses, the 5 to 6 people in person or so, and that includes the expert, Dr. Rohr, and then the people on Zoom. Is that with your satisfaction and agreement?
Sure.
Okay, those are the people that you want to have testify on your behalf, and those people are going to be testifying on behalf of other people as well from your family.
Correct.
Is that what you want? And your attorneys have talked to you all about this?
Yes, sir.
They've answered all your questions?
Yes, sir.
Anything else? Anything else from the defense on this issue?
As far as the witnesses, Judge, no.
Okay. All right. Thank you, sir. So then the only outstanding issue this time is the victim impact statements for review?
Yes, sir.
Okay, so obviously I have a jury arriving here any minute. What do you want me to tell them?
Judge, as far as the victim impact statements, Mr. Davis is going to try to review and line item the one. I'm going to try to do the other right now. We're going to work as quickly as we possibly can so that we can be ready to go. If there's no objection, we'll provide that to the state. If they're okay with striking whatever we have, then we can move forward. If there's going to be some additional argument that needs to be made, then I think we should bring that to your attention after we've had a chance to look at it.
How long do you need to review everything?
We've already looked at the one, so I think he's just going to mark what we discussed already. This is like 2.5 pages, so I'm sure I can read and start marking in the next 10 minutes, 15 minutes max.
Okay. How about I'll come back out around 10 o'clock, which is what I told the jury anyways. At that point, maybe we'll have at least one statement should be, you would think, close to being completed, and then we'll see where we're at in the other one.
Yes, Judge.
I just want to let the jury have some idea of what we're dealing with. That way they're not sitting in a room waiting for us. Just so you guys know, my office made contact with the 4 alternates. They were told to be present. Actual conversation and verbal contact was made with all 4 of them, and they told my office that they would be here by 10 o'clock for the proceeding. So let's come back out at 10 o'clock. We'll see where we're at, and we'll go from there. I will share with you guys the preliminary instructions as well. It should be complete, and I'll be ready reading to the jury as is. We can deal with the final instructions and verdict forms as we get there, although I probably will go ahead and share everything with you guys. That way you have everything. The verdict form should be rather complete. It has the aggravators, the state's listed. You guys can look at the final instructions. It has all the mitigators the defense is relying upon. And you can take a look at that. You weren't here when I told Mr. Davis this, Ms. Michelle, but I listed the mitigating circumstances as it was phrased in the pleading. I didn't really change anything up. Some of them seem to overlap a little bit with one another. Some of them have like the same beginning, but kind of go to different directions. So I put it as is. I didn't want to mess with anything. If you guys want to combine them or separate them out, I'll leave that up to your discretion as how you guys want to proceed in that regard. Some of them mentioned, he was 15 when he dropped out of school or something and had a child, and they kind of all talk about the same thing, but then go on a different branch off that tree. And that may be on purpose. I'm just letting you know what I did so you guys can take a look at it.
Yes, Judge.
Okay, so we'll be in recess till 10 o'clock.
Sir.
Let's go on the record. 19 CF 7518, State v. Johnathan Quiles. You have counsel of the state defense. Mr. Quiles present. I do have all 16 members of the jury accounted for.
Sorry, Judge.
How much time do we need?
We were actually discussing it with the state as far as doing some of the redactions. We were going over.
Give me a time so I can let the jury know, because they're waiting on us at this point. And I think my feelings about having them wait on us is quite apparent at this point.
I think 5 minutes would accomplish what we're doing.
I was going to say between the two, give us 10.
Can you let the jury know 10:30, please?
10:30?
Yes. And if they want to walk around, that's fine as well. Just be back outside here that we can start at 10:30. I'll see you guys then. I have counsel of the state defense, Mr. Quiles present. How are we at? How are we with the next statements?
Good news, Your Honor. We do have an agreement. And to make it simple, the state of Florida is asking to file a clean, original copy of both, one of Paula Dixon and the other of SS. And just for the record, it's Dixson is how she has it spelled in her victim impact statement. And then, Judge, we'd like to make this a court-only composite exhibit for the clerk to then file right behind it the exact same thing with the defendant's objections. One, the objections are noted in red, and on the other, the objections are noted in the highlighted yellow. What we've done, Your Honor, we'd like to file both sets of these to show, if needed, at a future date, the appellate court, what was objected to, and then the state has agreed to all the requested objections by the defense. So we have taken those out by providing a copy to each respective witness, blackened out of the exact same portions that were objected to, so then the record will reflect when they testify that what they'll read will actually match what has been objected to. So at this time, I'd like to file the first clean. It's one copy of both victim impact statements with no markings, and the second will be both victim impact statements with the defense requested objections that not disagreeing with.
So are these being filed on the docket, or are these being taken for evidentiary purposes?
Just for purposes of the record to be filed with the clerk. We're not obviously asking them to go back with the jury with all the markings on them.
So I guess my question is, are they going to be filed to where you can go on the docket screen and see these statements, or are they being filed for identification purposes only to where they're essentially part of the evidence that will go to the appellate court?
Judge, just file on the docket. Again, they're going to be reading this in open court, so we have no issues with it being filed on the docket.
Okay, so they're being filed on the docket.
Yes, sir. And then with the
Is there a better way to handle that?
Judge,
Maybe can they just be filed as for identification purposes for the appellate courts versus it being filed so there's public record on the docket now?
I have no objection to that if that's what the court requests, and there's no objection on the state.
Okay, so I can make them a court's exhibit. Obviously, if they're not my evidence, of course, but for purposes of just the evidentiary purposes, so they're not filed on the public domain, they can be made as court's exhibits 1 and 2. We all know what they are. Everyone's agreeing to what they are. It's just for purposes of so they can be sent to the appellate court for review at a later date if that's necessary.
Yes, sir. The state agrees.
Defense agrees to that, Your Judge.
Okay, so we'll mark court exhibit 1 will be the ones that they're actually reading, and then a clean copy. Then count 2 will be, or court exhibit 2 will be the ones that have objections to it. Is that how you did it?
That's right.
Oh, so is one court exhibit 1 is one witness, court exhibit 2 is the other witness?
No, sir.
Okay.
Court exhibit 1 is both victim impact statements, unredacted.
Okay.
So the appellate court will have that on the record, and then the second court exhibit will be both victim impact statements with the defense requested objection.
Okay, you said it better than me.
Yes, sir.
And so to get to the end on this, the parties have agreed, or the state is conceding to the objections made by the defense on everything raised off both statements, and that'll be presented to the jury.
Yes, sir.
Okay. So at this point, are we ready to proceed?
Yes, sir.
You guys have seen the plenary instructions. I'll read to the jury with the state's aggravating factors and what's applying to counts 1 and 2. That's really the only thing that's necessary for me to insert in the plenary instructions compared to the final instructions.
Judge, we just have to renew our prior objection that we had raised earlier for purposes of the appellate, stating specifically that we do not agree with the aggravator of the familial. I believe it was number 6 was the aggravator.
Correct.
We are objecting to that, Judge.
Okay. I don't think I asked the state for any position on that. Do you want to state anything more so than what the record already has on it?
No, sir. I think the court pointed out on the record it's familial or custodial, being that he's in a relationship with her as her uncle, and with his belief that was his child and the motive for the killings. We believe this, particularly the facts, and I'll get into the facts and argument later today. But with all the things that I'm too time-consuming now to go into, but with all the facts that bore out over the year and a half leading up to this, the state's position is that there certainly is a custodial relationship.
For scheduling purposes, I would probably get through openings and maybe the state's first 2 witnesses. The state will probably rest at that point. Probably take a lunch break then, and then I'll turn everything over to the defense, and then Zoom will be set up for you guys to use at your disposal.
Just so the court knows, our opening statement is brief. The defense has advised me that it's just 5 or 10 minutes, and the victim impact statements will be 15, 20 minutes, both reading them. So if the court wants to keep going, we're at the court's pleasure, but that we will rest at that point.
After they arrest, we could probably get through Dr. Rohr before lunch.
Do I need to dismiss the jury for any motion practice after the state's case? Okay. Any reason why I can't bring the jury in?
No, Your Honor.
Defense?
They are.
All right, let's bring the jury in, please. Okay, that's fine.
Your Honor, the jurors are entering court.